Hello, 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 everybody. Happy Friday. Welcome. Welcome in. Good to see you. Hello. Excuse me. Hello, hello. Hello, everybody. Hopefully, everybody survived. Survived enough, at least. It's been a week. Definitely been a week. Hello, hello, hello. Welcome, welcome. So happy Friday, everybody. I'm on just a little bit early tonight. I've got lots and lots of things to go through. So I wanted to make sure everyone was able to get their notification. So it was a baby quake. Okay. I'm just glad everybody is okay. I'm just, when anything like that happens, we just want to make sure everyone's okay. So hello, Suze. Good to see you. Good to see you. Wanderlusting. Hello. Welcome. Yep. It was like a 5 Mondays in a row. Oh, that's funny. That's really funny. Oh my goodness. Oh, Donna. Hello. Hello, James. Good to see you. Dancing Stars. Hello. Definitely retrograding. Oh my gosh. True. I knew something was going on. Hi, Mads. Happy Friday. Hopefully everything is going well. Adrian, hello, welcome. So happy Friday, everyone. Welcome in. I am just a little bit early tonight, but I think that is okay. John, that's funny. Morning quake and the evening aftershocks. Oh, excuse me. That's very interesting. You just don't hear about it a lot on the East Coast. So, and that with the solar eclipse coming, everyone, I just don't know. Yeah, the eclipse is in retrograde too. I know, it's just madness. Friday, absolutely. Next couple days should be interesting. I agree, everybody. Excuse me, I agree. So, there's just been a lot going on. There's been a lot going on with Mr. Trump here, too. D o'clock in here, so that's funny. So, will you be doing the Diddy case when it starts? That's a great question, Trish, and I'm just not sure yet. I have been gathering all of the, thank you, Ria. I've been gathering all of the lawsuits against Mr. Combs. It looks like there's like 5 or 6 lawsuits that are going, and they are all pretty yikes. So I won't say no. I'm trying to figure out a way to present them that's not overwhelming. So definitely will be keeping an eye on that. Any tips on avoiding jury duty? Oh dear. Well, we need you. We need everybody. Just be honest. Just be open, honest when they're asking questions or when you're filling out your forms. Just be as honest as you can be. And we need you. The system needs you. Wonderful job. Yes. Well, and I think that there's a lot of things at play in all of his cases that I think could be really interesting to go through. So I'm just trying to figure out, I had taken a look way back when the original lawsuits were filed and kind of gone through to figure out a way to present them. So I would definitely like to keep that going, but I will need a little extra time to try to figure it out. Why do they use a motion to quash and not a motion to dismiss? Great question. A Southern hush puppy. Oh, I wish I had hush puppies right now. That's like my favorite thing ever. All right. I digress. So a motion to quash is just going to depend on, which jurisdiction you're in. So in New York, a motion to quash is asking that a subpoena that's being requested be stopped. So it's asking a legal document to be stopped as opposed to a motion to dismiss. So a motion to dismiss is going to be off of an order. And that's going to mean, I have this order, I have this proceeding, and it needs to be dismissed. But a motion to quash means we're stopping a legal proceeding or a legal document from going forward. So they're amazing. Well, yeah, I know. They really are. Oh my goodness. So that's why we're using a motion to quash here. Again, we need to have a full order in order to do a motion to dismiss. Yeah, yeah. So tonight, everybody, I am planning. I have, as promised, I do have Mr. Trump's response to the court's March 18th order. So he has an interesting response here. It's only a few pages. And then he has included one of his attachments is the proposed jury instructions. And these are a lot different than the government's, a lot different. So I think that'll be really interesting. So I've got that to go through. And then I also have if we've got time, we'll see how things go. But I've also got the government's response to one of the amicus curiae briefs. So there have been several people who have been wanting to file amicus briefs in the Florida case, everyone. So different like spicy potatoes. A little bit. It's a little different. But this particular filing had to do with, this group had said that the special prosecutor didn't have authority to even bring this case. And so the special counsel disagreed with that. So he has filed, or his team has filed a response against that particular brief. So we'll see about getting into this one. This one's a little bit more technical, but of course, well written. So we'll have to see if we've got time for that tonight. But I did want to start with the latest news out of the New York case because, of course, we're getting so close to that New York trial at this point. So I think we had spoken before regarding Mr. Trump had filed what's known as issued. So that's another issue too. When you're not seeing a motion to dismiss, it's because we've already got something that's been set out. Grab another pen here. So has issued a subpoena ducis tecum. Now that's Latin, and I'm sure I'm mispronouncing it. And that's just meaning like I want you to present any information that you have. Seeking all materials related to a documentary film that's coming out with Miss Daniels. So he had issued the subpoena, and there had been a motion to quash put out. I will walk you through this because you can't just go fishing around saying, hey, I just want anything you have about anything in the world. You actually have to have some parameters, and Mr. Trump didn't have any parameters. So yes, so these tonight, these are a new kind I'm trying out. I've not used this brand before, but these are press-on nails. I play guitar, so I do like to be able to take them off whenever I want to be able to sit down and play. So well, welcome, Tiburon. Good to see you. So the judge just issued today this order agreeing, yes, we need a motion to quash because this was essentially a fishing expedition, which isn't allowed in the legal field when it comes to affidavits. And so his subpoena has been quashed. So this is out of New York. So I thought I would just start us off with this. It's only a couple pages, so we can start here and then dive into Florida real quick after that. Yes, there's a lot going on. So in another, just as a quick side note to everyone, we also talked, how am I feeling? I'm feeling pretty good. I'm feeling pretty good today. Always happy when it's Friday. We talked before, and I went through Mr. Trump's letter in the New York case. He had a letter where he had filed basically requesting permission to file a motion for a recusal. Now, Mr. Trump has kind of been messing up a lot of his filings, and so Judge Merchan said, dude, if you're going to file stuff, you need to ask permission first. You need to give us some notice. So he filed that letter. There has not been a response from Judge Merchan, but here we go. Today, we have a recusal motion that has been filed. So I'm a little bit suspicious, everybody, because he is supposed to get permission before filing, because when he's just filing these things, he's kind of creating this big whirlwind of madness when it's inappropriate. So he has technically filed a recusal motion, but He did not comply, as far as I can see, with waiting for the court's permission. So I'm actually not even going to go through this at this point. Yes, they were supposed to get permission to file. Exactly, Matt. So I'm not going to go through this at this point. I do have it printed because I do want to make sure, for me, I want to have a full file. But if you're interested, you can go online and take a look at it yourself. But in my opinion, he needed to wait for permission. He didn't have it, as far as I can see, based off of the filings. So I think that this has been a bad filing. Just kind of a heads up on that. So this is the motion to quash order here. When was it filed? Today. It was filed today. Not normally required to ask permission. No, they're not. No, they're not. It's just because he has been filed so many inappropriate things that the judge is saying, hey, you need to run it by me before you start filing everything on the public docket, because you're screwing up our docket here. You're screwing up the record. So yeah, I didn't need approval from a judge for a recusal of that judge. What judge would approve? Well, Jedi, the key was here. There was a letter asking him to file a motion for recusal, and so he needed a yes or no on that, because at this point, I don't even believe filing a motion for recusal is appropriate procedurally. He's already been denied the recusal already. They've already kind of gone through this. So the fact that he's filing it this close to trial is completely inappropriate. So, yes, they already filed. Yeah. And, if he wants to file again, whatever. But he filed his letter. He did not get a response, but he went forward and filed the motion again. So it's just a situation where, I don't think it's appropriate. I don't think it's appropriate. All right, let me go ahead and start reading through this real quick, everyone, and then we'll dive into Florida. So this was just issued today. On April 4th of 2023, Trump, the defendant, was arraigned before this court on an indictment charging him with 34 counts of falsifying business records in the first degree in violation of Section 175.10. On March 11th of 2024, defendant issued a subpoena, ducis tecum, to NBC Universal, seeking all materials related to the documentary film titled Stormy Daniels on, I guess it's just titled Stormy, hereinafter called the documentary. That involves a witness in the instant matter, Stormy Daniels, hereafter referred to as Daniels. On March 20th of 2024, NBC filed a motion to quash the subpoena. Defendants responded on March 27th, and NBC filed a reply on April 1st. And I have gone through and read those documents just as a heads up. So here's our motion to quash. So I think it's important to remember what a motion to quash is. And under New York rules, section 610(20) provides that any party to a criminal proceeding may issue a subpoena, specifically providing that an attorney for a defendant in a criminal action may issue a subpoena of any witness whom the defendant is entitled to call in such action or proceeding. To sustain a subpoena, the issuing party must demonstrate that the testimony or evidence sought is reasonably likely to be relevant and material to the proceeding, and that the subpoena is not overbroad or unreasonably burdensome. So this overbroad issue is really important. So citing case law here, the proper purpose of a subpoena, ducis tecum, is to compel the production of specific documents that are relevant and material to facts at issue in the judicial proceeding. When disputes arise concerning the validity or propriety of a subpoena, the court must resolve whether the subpoena is enforceable. And then we're citing case law here. Because the subpoena materials are returnable to the court, it follows that the court retains the ultimate authority on the outer parameters of the subpoena powers. The Court of Appeals has held that a subpoena is properly quashed when the party issuing the subpoena fails to demonstrate any theory of relevancy or materiality, but instead merely desires the opportunity for an unrestrained foray into confidential records in the hope that unearthing some unspecified information will enable them to impeach witnesses. Impeaching means to question their credibility on cross-examination. A subpoena, ducis tecum, may not generally be used for the purpose of discovery or to ascertain the existence of evidence. Conversely, courts have denied a motion to quash where the subpoena demands production of a specific of specific documents which are relevant and material to the proceeding, citing case law here, where the defendant established that the solicited data is relevant and material to the determination of guilt or innocence and not sought solely in speculative hope of finding possible impeachment of witnesses, general credibility. So we're citing more case law here as well. When deciding a motion to quash a subpoena, access must be afforded to data relevant and material to the determination of guilt or innocence. For example, when a request for access is directed towards revealing specific biases, prejudices, or ulterior motives of the witness, as they may relate directly to issues of personalities in the case at hand, or when it involves other information which is known to the trier of the fact, could very well affect the outcome of the trial. There's no such compulsion when requests to examine records are motivated by nothing more than impeachment of witnesses' general credibility. Citing case law here. Thus, this court must determine, among other things, whether the subpoena seeks information to be used for impeachment of general credibility or is instead directed towards revealing specific biases, prejudices, or ulterior motives related directly to the personalities or issues in the matter, whether the solicited information is material to the question of guilt or innocence or nothing more than a fishing expedition. And this fishing expedition is very important. So this is 3 pages total. The civil rights law provides statutory exemption from contempt for professional journalists, newscasters, and their supervisors and employers. So again, he subpoenaed NBC, everyone. New York Shield law provides journalists an absolute privilege from testifying with regard to news obtained under a promise of confidentiality, but only a qualified privilege with regard to news that's both unpublished and not obtained under the promise of confidentiality. And then we're citing the New York Civil Rights Law here. A party seeking unpublished news may overcome the qualified privilege by making a clear and specific showing that the news, 1, is highly material and relevant, 2, is crucial or necessary to the maintenance of the party's claim, defense, or proof of the issue material thereto, and 3, is not obtainable from an alternative source. And then we're citing the Civil Rights Law here. Establish the qualified privilege as to non-confidential news by requiring disclosure of non-confidential material only as a last resort. And then we're citing for the case law. So now we'll get into the discussion whether the judge will make his ruling here. Yeah, I'm not enjoying this font either, Hitch. I'm with you on that. Well, I would do a sticky note, but I'm about to flip. I'm about to be done. Let's hold on, everyone. I've got plenty of stickies for later. Yeah, the font is unreadable. I agree. I'm struggling myself. For the following 2 reasons, a non-party NBC Universal's motion to quash the instant subpoena is granted in its entirety. First, defendant's request seeks all documents that relate to the documentary and one or more of the following topics: A, the premiere of the documentary; B, the release date of the documentary; C, editing of the documentary; D, promotion of the documentary; E, marketing of the documentary; F, any form of compensation to Stephanie Clifford related to the documentary; G, any rights of the documentary maintained by Stephanie Clifford; H, agreements between Stephanie Clifford and the NBC Universal or any of its affiliation. Wait, did we just do H? I thought this should be I over here, but that's a P. I guess we've skipped a few. P, the trial in People v. Trump indictment number 7154-3-23 involving charges filed by the Manhattan District Attorney's Office. Q, Michael Cohen, or R, Donald J. Trump Exhibit E here. So Miss Daniels sat down and did interviews multiple times with NBC quite a while ago, actually, regarding her story. So the documentary is released or set to release, and the timing of it, Mr. Trump is saying, is suspicious because of the trial. Unlike the subpoena in this case, Kozlowski, which a defendant relies on, the instant subpoena is far too broad and seeks general discovery. In Kozlowski, the court held the subpoena met the minimal threshold necessary for enforcement, but requests there were highly specific and narrowly tailored. The defendants in Kozłowski made requests that sought specifically identified statements. In the instant matter, the defendant seeks all documents, including but not limited to vague and overbroad requests for the trial. In People v. Trump, in this indictment number here, defendant claims that the materials sought by the subpoena will establish collusion between NBC and Daniels relating to the release date of the documentary. Defendant argues that NBC and Daniels conspired to release a documentary as close to the start date of the trial as possible to prejudice defendant and maximize their own financial interests. NBC argues that defendant's claims are devoid of factual support and corroboration. NBC reply memo here. The affirmation of Erica Fordstadt, the Senior Vice President of Production and Development at NBC Universal, indicates that Daniels had no right to approve the content of the documentary or the timing of its release. Because defendant's claims are purely speculative and unsupported, his subpoena and demands therein are very definition of a fishing expedition. Second, even if this court were to find the defendant's request was not speculative or that it seeks general discovery, NBC's motion nonetheless would be granted because defendant seeks unfettered access to the notes and materials of a media organization in violation of Civil Rights Law, Section 79. So, this court has considered defendant's explanation for seeking this court's permission to rifle through the privileged documents of a news organization and finds that he has not shouldered the very heavy burden necessary to overcome the New York Civil Rights Law. The foregoing constitutes a decision in order of the court and then filed April 5th by Judge Mershon here. So, there we go, everybody. That was just a real quick overview here of Judge Mershon denying the subpoena that Mr. Trump had issued for NBC on the Stormy Daniels documentary. Yep, just doing a quick overview. Oh, happy birthday. Well, whatever she's hiding in her documentary, so it will be. It will continue to be hidden. All right. So there we go with that, everyone. Good judges out there. I know. It's a good documentary. I've not seen it yet, everyone. I've not seen it. Yes, happy Friday. I'm extremely excited that it's Friday, everyone. I'm going to get my sticky note ready. I have my little sticky note case here. So, get my sticky notes out. Excuse me. I'm not sure if it's already out. Excuse me. I heard someone say it was already out on Peacock already. So, what's going on with his bond? So, yeah, it just sounds like his bond company needed to give some extra information to clarify that they were good enough. Yes, sticky note. I do have a sticky note case. I do. I just found this, digging around in the basement. Who doesn't dig around in the basement? So I just found this old case, and it was just the perfect size. So, indeed, I will have a sip of tea. Thank you very much. Whatever sticky color means, well, at some point I will. I will say blue usually represents New York. Oh, my goodness. My color coding system is just for fun. That's for floppy disk. Yeah, so somebody told me that. I think the last time I showed it, because there's this 3M on here, somebody told me it was for floppy disks. But, I don't know. It's just the perfect size for the sticky notes. It just fits the sticky notes perfectly. So, yes, I think so. Released March 8th. Oh, good to know. Okay, floppy disk case. Yeah, I think so. My significant other has a whole bunch of boxes from when he got his PhD, his doctorate. And so I was just sifting through them and came across it. I don't know what was in it. I just dumped everything out and took it. Don't tell him, though. There might be something important that was in there. I just dumped it out. I was like, whatever. What can I use that's in here? Oh, my gosh. Yes, we're big into reducing, reusing, and recycling as best as we can. So, Clinton era, oh my goodness. Oh my gosh. Yes. Yes, that's right. He signed a contract that I would go through all of his stuff and take whatever I wanted. If he has a reader, he may not. I don't think so. I don't. I don't know. Oh my goodness. Yes, yes, yes. All right. Oh my gosh. All right. So let's dig in here to the Florida case. Florida. Oh boy, excuse me, everybody. I apologize. Boy, I tell you, my cough goes and then comes back, it seems like, when I'm just trying to speak. One Apple computer when they came out. Oh my gosh. Yeah, I mean, I think we can reuse everything, in my opinion. Reuse everything you possibly can, everyone, as best as you can. So this is Trump's jury instruction here. So his jury instructions that he filed. Oh, good. Oh, good. Love that, Lisa. Lawyer making yes. Yes, yes, indeed. Oh my gosh. Yeah. MTG saying the eclipse is a sign from God. Well, I mean, she says a lot of stuff. She's a lot of interesting things to say. Oh my goodness. Macintosh. Oh yes, yes. Oh my goodness gracious. Memories, everyone. Memories. All right, so let me give you an overview here before I start diving right in. We have over the last few days in the Florida case. Excuse me. So there was a request for both sides to submit proposed jury instructions. There were some questions about the Presidential Records Act that the judge wanted to, I guess, kick around. So Jack Smith and his team has filed their response. I did go through that on Wednesday. It was a bit of a spicy potato with that. Post-it notes are older than the floppy disk. Oh, I love it. Yes. So here's the deal. So she had set out these two scenarios, and she had told both sides, give me some jury instructions that you think would be helpful with these two proposed scenarios. Now, in Jack's filing, his spicy potato, he came in with his jury instructions and said, well, I can't because the premise that you're setting out in your hypotheticals is completely wrong and is not in compliance with the law. And then today we have Mr. Trump's response. So how jury instructions work, at the very end of the trial, when all the evidence has been presented and both sides are done with their cases, then, yes. So we have, the judge will instruct the jury on what they're supposed to do. So there will be a batch of just general instructions, like where you're supposed to go to deliberate, don't talk to other people, what your job is as the fact finder, just some general instructions. But then he will or she will start to give more detailed instructions on, in this case, we're dealing with, let's just say if it was an assault case. So we're dealing with an assault case. These are the elements of what an assault are. And the government has to prove each element beyond a reasonable doubt. And you have to show this level of intent and what this intent means. And you have to show that this kind of harm was done. So what does harm mean? And so it's literally a packet of instructions. And when the jury goes through, they answer the first question. So did you find that, there was some harm done here? Yes. And then it'll say, go to question 2. And they go to the next question. So they go down and they answer every single question. And then when they get to the very end of the jury instructions, you'll have your full verdict. So a lot of times what we'll do when we have specialized cases is that we'll ask for proposed jury instructions to kind of tweak the language because we have all these general ones, right? So if you have a general list of the elements for an assault or the elements for a crime or the elements for intent, that's no problem. But here we're dealing with classified documents. And so we do have some examples of jury instructions, but she wanted to kind of kick around this idea of, somehow including that the jury would somehow be able to decide, what the record was. So, which is irrelevant under the classified records law. But so that's what Jack was saying. And so what Mr. Trump's done here is first he's just blowing a lot of hot air. The first whole batch here is more of like I've been so wronged. I've been wronged by even having to say anything, blah, blah, blah. And then his exhibit, which I'll show you next, he's actually going through and setting out his proposed jury instructions. So he's setting out what he thinks should be given to the jury to define possession, unauthorized possession, a person entitled to receive it, national defense information, closely held, potential damage, willfully. So he's setting out in a technical way that we would have for our jury the different ways that he thinks each one of these should be defined for the jury. So the jury would say, yes, the government proved this, no, the government did not prove that, blah, blah, blah. So he has set out his proposed ones, just like Jack did, that we went through on Wednesday. So our jury instructions really are the guide for our jury because they're just everyday people. We pull people in off of the street, and we say, hey, listen to all of the information we're giving you, and then answer these questions. And you don't have to be a lawyer. You don't have to be involved in the law in order to come up with a verdict. You just need to answer these questions. So that's really how jury instructions work. Now, some cases, some judges want to kind of discuss it throughout the entire case. Most judges wait until the very end to start going through jury instructions. So, a couple of weeks before the case is about to end, or even just a day or two, they'll start talking about it. So it really depends on your judge. It is relatively unusual for a judge to be asking for proposed jury instructions before she's even set a trial date. That's very unusual. We don't even know when the trial's going to be here. So she hasn't even finished ruling on her motions to dismiss. So I don't know. This whole thing was a little bit odd. But, and then using these two scenarios that were, not actual legal premises. So it would have been the same if she had said, why don't you propose some jury instructions talking about a unicorn prancing through, a river on their way to catch, the Pharaoh in Egypt. It would have been the same thing. That's the equivalent legally to what she was asking, because she was asking something that was completely not part of the legal system. So you just have to be... I have drumstick pencils, everyone. I do have two of them. I really like them because they're a little bit longer. So, yes. Oh my gosh. I have a drummer in my world, so I have borrowed the drumsticks. Oh my gosh. Yes. Canon, I think, is... Yes. Well, it's nice because when you get annoyed, you can just, Hawk does need a set, Suze. I should send him a set. It helps a lot. It helps with the thinking. So, excuse me. Yeah, she is. She's really, I don't know what she was doing. And she came back with a real spicy response yesterday where she's like, government, you're being rude. I don't know about that, but. So, you would love that. Oh, I should send some out. They're very fun, and it's nice because it's a much longer tool. I have this one, and then I have my chopsticks. These are my two longest ones. So I think you can get them on Amazon. I got these. I think these were just at our local music store. So. Excuse me. Yes, so they're little for when you get really annoyed. That works out. Oh my goodness. No, I don't play drums. I do play guitar and violin. I play in piano, although, I dabble in piano. But those were the days. Use a broken antenna, genius. Love that. Love that. Best office supplies. Well, yeah, I've got a problem. I have a problem. I don't like she was so rude to Jack. I agree. She was a bit hostile for sure. Mandibus, if there ever was a valid case for it. Mandibus is such a rarely used situation, but this may call for it. It may be appropriate. All right, so let's go ahead and dive in, everyone. This first part, again, is just kind of Mr. Trump's, introduction to answering her motion or her order. And then the second part actually gets into really the meat of what she was asking for and what he thinks it should be called. So here we go. President Trump's response, again, you'll always know who's filing this because he is filing it as President Trump. His response to the court's March 18th, 2024 order. Again, that was where she asked both sides to respond to these hypotheticals for proposed jury instructions. President Donald J. Trump respectfully submits his response to the court's March 18th order regarding proposed jury instructions relating to counts 1 through 32 of the superseding indictment. Attached as Exhibit A are the proposed jury instructions addressing Scenario A from the court's order with annotations and additional sub-exhibits providing supporting legal authorities. And I do have that Exhibit A printed out. We'll go through that next. So we do have footnote number 1 here. President Trump reserves the right to submit supplemental and or modified instructions relating to counts 1 through 32, the other charges in the superseding indictment, additional defenses developed as the case proceeds, and any other issues pursuant to Rule 30A and on a schedule set by the court. President Trump further reserves the right to file objections to proposed jury instructions submitted by the special counsel's office in response to the court's March 18th order at an appropriate time prior to any potential trial in this case. Prior to any potential trial. That's bold. So this was just unnecessary. She's asking for proposed jury instructions, so you don't really have to reserve anything because these aren't actual jury instructions, but whatever. Attached as Exhibit B is a proposed verdict form relating to Scenario A, which uses count 1 as an example for each count 1 through 32. Scenario B from the court's orders addressed below in connection with President Trump's renewal of his pretrial motion to dismiss counts 1 through 32 on vagueness grounds. So let's pause for a minute. She's already dismissed his motion to dismiss on vagueness grounds. All right, she's got a whole bunch of motions she's not answered, but one that she has answered is vagueness, and she's answered it, 6 weeks ago. So he is renewing his pretrial motion. That's not a thing. That we don't do that. You don't renew your pretrial motion in your proposed jury instructions. So this is just kind of like, fingernails on a chalkboard, if anyone knows what that is. Because she's already ruled. She said, no, we're not going to dismiss on vagueness grounds. The Espionage Act is valid and already decided that. And so he's renewing his pretrial motion. So yikes, that's just bad legal writing, in my humble opinion here. So, and because the court's correct statement of the law, wow. So this correct statement of the law is exactly what Jack was saying is not correct. Of the law in Scenario B means that counts 1 through 32 fail to state an offense under Rule 12b3-4. So we are just right out the gate. We're already in trouble here. So one thing that I have been thinking about as I've gone through this, everyone, is this idea that is it possible Judge Cannon presented these two scenarios that had incorrect law written on them to give Mr. Trump's team a chance to actually go through and recognize that their defense is coming at it from the wrong angle? I don't know. I don't know. I doubt it, but you just never know. I was thinking about that on her response to Jack when she said she was just asking for ideas. My question is, well, maybe she was trying to show maybe she was trying to show Trump's team, like, hey, move on, She's not that clever. Could be, could be. This important exercise further, excuse me, illustrates that crafting instructions applying the Espionage Act, in this case, would require recourse to judicial gloss and other authorities not included in or authorized by the statute, such as Executive Order 13526 and the Presidential Records Act. Therefore, as applied to President Trump, Section 793E is unconstitutionally vague and no law at all. So he's claiming that this section of the Espionage Act does not apply to him. Oh dear. We therefore renew President Trump's void for vagueness challenge. All right, we're renewing another challenge. Okay. We don't do that. Which the court denied without prejudice on March 14th of 2024. Without prejudice just means it was denied, but he could raise it again. But I think she meant raise it again at a later point when new issues have been brought up. But whatever. Yes, I do need to grab another lozenge. Sorry about that, everyone. Okay, so to be raised as appropriate in connection with jury instruction briefing and or other appropriate motions. Under Davis, neither an Article III court, nor, this just means a federal court, nor a jury can address the constitutional problems that we have outlined in prior submissions and at the March 14th hearing. So I'm taking a moment to pause because we're saying neither the Article III court nor a jury can address the constitutional problems that we've outlined in prior submissions. So he's saying that no court or jury can deal with the constitutional problems that they're raising. So right here, he's saying basically our court system doesn't have authority over him. So this is quite troubling right here. We'll just take a moment to acknowledge that. So this sentence is like, the courts don't have power over me. To hold otherwise would be to hand off the legislature's responsibility for defining criminal behavior to unelected prosecutors and judges, as well as jurors, and to leave people with no sure way to know what consequences will attach to their conduct. And of course, that's way out of context, and that would be to completely upend our entire judicial system. Yeah, it's very frustrating. Here, the role of the courts under our Constitution is not to fashion a new, clearer law, to take Section 793E's place, but to treat the law as a nullity and invite Congress to try again. So he's saying that the court should say that the Espionage Act section here is null and void, and that Congress should rewrite it. Well, that's interesting. That is a situation for Congress's own making due to the body's failure to address decades of judicial and public concern relating to obvious and unacceptable ambiguities in the statute. So again, he's saying that the Espionage Act should be null and void. Citing here the Espionage Statutes and Publication of Defense Information of 1973, explaining that key terms were formulated with hopeless imprecision, and as a consequence, the legislative materials indicate a basic and continuing congressional confusion about the ends sought to be achieved. By the way, all of this has been clarified through decades of case law. Just clarifying. Leads me to wonder, jury's judicial review is a thing. They have nullification. So, right. So our juries are fact finders. So when you're saying judicial review, that to me is a legal standard where judges make a ruling on whether a law is constitutional or not. That's a legal standard. That's not a fact standard. So juries don't make decisions of law. They make decisions of fact. So, that's trying to kind of being meshed up here. You have to separate those two things out. Yes, he's saying he's above the court. Not only that, but he's saying that the court needs to nullify the Espionage Act because he thinks that it's incorrect. So Congress needs to go back and rewrite it because he thinks so. In addition to the fatal vagueness problem, the court has correctly stated the law in scenario B of the March 18th order. The superseding indictment alleges, and the special counsel's office has elsewhere conceded, that President Trump caused the records at issue to be removed from the White House during the end of his term in office. Thus, it's undisputed, as stated in scenario B, that this case involves an outgoing president's decision to exclude what she considers to be personal records from presidential records transmitted to NARA. This is completely wrong. Based on the Presidential Records Act, it is simply not the case as a matter of law that President Trump was unauthorized to possess the documents in question under Section 793E of the Espionage Act. There can be no appropriate jury instructions relating to factual issues in a scenario B because that scenario forecloses prosecution of President Trump on counts 1 through 32. Oh my gosh, everybody. Oh my gosh. Oh my goodness. I'm about ready to fall off my chair. I'm gonna fall off my chair, everybody. Here we go. All right, so Jack said, dude, I can't give you instructions because you've misstated the law. And now Mr. Trump, oh my gosh, is saying, I can't give you jury instructions here because it presumes that you can prosecute me. And that's incorrect. Oh my goodness gracious. What is happening? This is ridiculous. All right. Shake it off. The result is not, as the special counsel's office has argued, an implied repeal of Section 793E, but the Presidential Records Act. So now he's saying we need to repeal the Presidential Records Act as well. Oh my gosh. All right, so everybody, so far, let's just keep track of what we need to repeal. 1, the Espionage Act needs to be repealed. And 2, the Presidential Records Act also needs to be repealed. All right, so let's just keep track as we go through of our entire judicial system being repealed here. All right. Rather, counts 1 through 32 did not state offenses under these circumstances, and the office cannot meet its burden of proof on those charges. Setting aside the vagueness problem, Section 793E remains on the books, but it does not prohibit the conduct alleged by the office against President Trump. Specifically, under Judicial Watch, which was a case mentioned by Jack and his team, backed by decades of practice by NARA under the PRA, and consistent with the history of former presidents and government officials retaining classified records when they leave office, an outgoing president's decision to exclude what he or she considers to be personal records from presidential records transmitted to NARA constitutes a president's categorization of those records as personal under the PRA. Oh my gosh. Oh my goodness gracious. And then we're citing 44 U.S. Code Section 2203F, mandating that during a president's term that the president shall remain exclusively responsible for custody, control, and access to presidential records. Right? Well, President, let's just add that here. Well, President. Oh my goodness. And then we're citing the Judicial Watch case. The PRA does not confer any mandatory or even discretionary authority on the archivist to classify records. So let's be clear, everyone. The Presidential Records Act doesn't confer any authority to the archivist to classify records. So the archivist cannot classify records. All right? So we've all learned something new. Our personal records stamp classified. That's a great point. Oh my goodness gracious. All right, here we go. Wouldn't the lawyer be called out for submitting this? You know, I keep thinking each time there's a filing that they're going to be called out, but then to my surprise, no, they're not. Neither a court nor a jury is permitted to make or review such a categorization decision. due to inter alia the separation of power concerns such review would present. And then we're citing the Armstrong case. Congress was also keenly aware of the separation of power concerns that were implicated by legislation regulating the conduct of the president's daily operations. And the Cheney case, reasoning Congress's limited scope of judicial review and provided, what? Limited scope of judicial review? Congress doesn't have judicial review. All right, whatever. Authority for the president, the vice president's document preservation decisions. I cannot guarantee that these quotes are correct, everyone. I just can't. All right, so courts may review guidelines outlining what is and what is not a presidential record to ensure that materials that are not subject to the PRA are not treated as presidential records. Here, considering judicial review of policies and guidelines that exclude from the reach of the PRA all but a narrow category of vice presidential records. In American Historical Association v. Peterson, for example, the court in a civil case reviewed an agreement between NARA and the Bush administration that, in effect, created the types of policies and guidelines discussed in the Armstrong-Cheney cases, considering judicial review of agreement that on its face constitutes an opting out of the provisions of the PRA governing the archival's disposal of presidential records following a term of office, which are distinct from those that govern disposal of presidential records by an incumbent president. Peterson held that this matter is subject to judicial review because the archivist compliant with the PRA is reviewable. I don't know, everyone. I just can't guarantee that any of this is correct citations at all at this point. However, whereas Peterson, Cheney, and Armstrong 2 involve guidelines and policy level applications of the PRA, Judicial Watch involved a type of document-specific PRA categorization issue that is presented in this case. So, the Presidential Records Act, again, everyone, is an administrative process here. It's an administrative act regarding presidential records. The Presidential Record Act does not cover classified documents. Just clarifying that. In that context, the Judicial Watch Court concluded that a close reading of the Armstrong 2 decision suggests that the limited judicial review authorized by the D.C. Circuit left untouched that portion of Armstrong and gave the president unfettered control over his own documents. Again, unfettered control over his own documents. It does not say unfettered control over classified documents. To the extent Armstrong 2 authorized anything, it was a civil proceeding to review guidelines outlining what is and what is not a presidential record under the terms of the PRA, which is fine. You can review what a presidential record is. The issue in this case is what a classified record is. The D.C. Circuit was clear that such civil review was authorized for the limited purpose of ensuring that they do not encompass within their operational definition of presidential records materially properly subject to the Freedom of Information Act. So, classified records in the Freedom of Information Act have their own. What does ID? ID just means citing the previous citation. So if my citation is exactly the same, see here it says 1F third. So this is a case citation. So this is a Federal Reporter at page 1290. And so this is saying that the further quote is also on page 90. So if you're not changing the page name, then you don't have to add it. Yeah, absolutely. The Biden administration and NARA never attempted to obtain such civil review, preferring instead to weaponize DOJ and the Special Counsel's Office in furtherance of their election interference mission in a manner that, if not halted, would read out of existence the Presidential Records Act and the above described authorities interpreting it. Hold on, wait a minute. I thought he said that the Presidential Act and the Espionage Act needed to be redone. No, freedom of information. You don't have any freedom of information for classified records. No, it's not. No. Good question, TC. Right. All right. Oh, my goodness gracious. As is clear from Judicial Watch here, it provides no authority for judicial review of document-specific PRA categorization decisions in the context of criminal investigation. much less a criminal jury trial. Because that's so, a matter of law, the office cannot establish that President Trump's alleged possession of certain documents was unauthorized under Section 793E for purposes of counts 1 through 32. The merit of the proposition, as properly articulated in the court scenario B, has implications for several pending motions. So we'll just take a moment, everyone. We're going to take a moment because I think we have a fundamental issue here. All right? We have a fundamental issue. So he's saying presidential records and their categorization is improper, and my thought is fine, but we're not talking about presidential records. That's the fundamental problem, everyone. He's saying there's all these rules or lack of rules for presidential records, and I'm saying okay. But we need the rules for classified documents because those are the actual documents we're dealing with. We're not dealing with presidential records. We're dealing with classified documents. This is excruciating. Excruciating. All right. So first, the court should grant President Trump's motion to dismiss the superseding indictment based on the PRA, which she has already ruled denied. So she's already denied this. So we're granting that's already been denied. The charges fail to state an offense because there's no basis for the special counsel's office, this court or jury, to second guess President Trump's document-specific PRA categorization. So, why is Jack putting up with this? Well, he has to. He has to. I mean, what can Jack do? You've got this, you've got dingleberries filing a bunch of baloney. What can you do? And they keep filing the same thing over and over and over again. All right. Second, the lack of legal authority and historical precedent for reviewing President Trump's PRA categorization decisions support the pending selective and vindictive prosecution motions to dismiss the superseding indictment, which the court should grant or at a minimum order discovery and hold a hearing on those issues. So he's saying, what would a presidential document include? So, we have the Presidential Records Act that lists what documents would be included. So, for example, journals. All right. So journals, or if you wrote down stuff every day, or if I don't know, just those kinds of documents that are involved in the president and whatever he's doing in his office. So today I had Celine Dion's autograph on my photograph. Yay! Like that. Those would be presidential records. Any of those kinds of things that are included, because the National Archives says, we want to keep those. We want to keep those things. We want to preserve them for history. So what did you do in order to do your job? Like how did you go about doing your job? All right. As opposed to, this is a set of nuclear codes. So that's like content, right? So that's a specific kind of content. Presidential records isn't really about the content. It's about things created to kind of show this is how I did my job. All right. So, so a content versus a process. One has to do with kind of process documents, journals, tape recordings, whatever. Here this is how I went about my day. Here's my bicycle. Versus, hasn't Celine been through enough? She really has. Versus classified documents. So the issue here, and NARA originally was trying to get presidential documents from the presidential records from Mr. Trump. So they're flipping through and they're like, okay, where are his journals explaining, how he as the president like to go and think about stuff? I know, it's funny. And then instead they're like, oh, look, here's some nuclear codes. So it's content versus process. I think that's the easiest way to process or to think about the Presidential Records Act. So records created in the presidency to show how the presidency functions, how the president did his job, versus here's a list of the nuclear codes, here's a list of military plans, here's a copy of a military base. Those are classified military records. Now, if he was to write on a sheet of paper, "Dear Diary, today I received a map of a really interesting military base, and I thought it was fascinating. After I got the map, I decided to have a cup of coffee and think about that map for a while. And then I put the map away." That would be a presidential record. All right? But the map itself is a classified document. Oh, for goodness sake. Oh my gosh. Right. So it's something personal, like something that you wrote, you created, something the president created whilst doing the job. The president isn't creating a military map. Well, I don't know. Maybe he's playing a game with someone. Maybe he's like, "Boris, let's play," and he draws out a map. That could be a presidential record, but come on. All right, okay. All right. So notes, memos, etc. Exactly. Or, recording. Like if you hit the record button when you're like, "Okay, day 152, and we have discovered new life, and it's been very exciting, blah, 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 blah." That's fine. You can make that. So, did you see his map on a hurricane? Okay, that's a great example. Let's talk about the hurricane map, okay, everybody? Let's use that. Hold on. Hold on here. I have to verify that I'm a person. There we go. Did I make it? Okay, I did. Let's use the hurricane map, okay? Let's use that. That's the perfect example, everybody. Here we go. So right now, we have a map of the United States, and there's a hurricane coming, all right? Now, this is just a map. That's fine. But once Mr. Trump starts drawing on it, like la, 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 now this is a presidential record because he created that. He created that in his function as the president. Now, if for some reason the general came in later and was like, "Sir, I need to show you something." And so he's like, "Over here and over here and over here. This is where all of the nuclear weapons are. And there's a secret military base from aliens from the planet Jupiter over here." And he writes that on the map. Now it's classified. Now he can't have it. So if he had just stopped when he drew a picture of himself on the map, he could have that map. That's fine. As long as he told Nara about it, and Nara was like, "Okay, we got it." But once the general came in and put classified information on it, now he can't have it. That's not his now. Right? You can't have it. That's it. All right. Okay. Now he's going to sell the infamous Sharpie map. Oh my gosh. It hurts because it's true. Oh my gosh. All right. Yes, the illustrations, everyone. I know. This is why y'all come. This is it. This is this is the quality we're all looking for. Okay. All right. Now let's take it one step further, everybody. Let's say the general comes in and cuts the map. He cuts it and is like, "Whoops, sorry, this is mine," and takes it away. And so there's no classification marking on it anymore. Now Mr. Trump can have it again. It's a presidential record. Oh my gosh. Okay. All right. Let's get to the next point. Now, if he added notes to it, it'd become a presidential record. Exactly. Now, if another general came in and had a stamp that said classified, then it wouldn't be anymore. Oh my gosh. Maybe I should do a puppet show for Mr. Trump. Before and after. I can't mention the... Right. The hurricane took out the subs. So the subs are gone now. So he can have it now. Oh my gosh. Right, to-do lists on the back of classified documents. See, that's the thing though, Suze. That's the thing. All right. Let's just address that one last moment. All right. So let's just say we have a classified document here. And we'll just keep going with the nuclear codes because that's what he, had. So we have the nuclear codes and it's classified. Let's make this a little more authentico here. So classified documents. Now on the back, Mr. Trump wrote his grocery list. So number 1, give me some Diet Coke. All right, he wants Diet Coke. Number 2, bronzer. All right, so this side is classified. This side has a list. Maybe that's a presidential record because it's a personal list. But because it's classified on one side, the whole document is classified. The whole thing is classified. If any part of the document is classified, the whole thing is classified. That's it. That's it. You're done. You're done. So he might have thought, well, it's just got my grocery list on it. Whatever, I'm just going to take it. That would be wrong. That would be incorrect. That would be incorrect. He thinks that things go the other way. I agree, Suze. I think he thinks if I write my list for bronzer down on a classified document of military plans, I can keep it. But no, the classified piece still is there. It's still there. You should present this at trial. Oh my gosh. I need to make a PowerPoint for Mr. Trump. And catch up. Okay. All right, everybody. All right. So there we go. Classified versus presidential records. All right. All right, here's third. Here we go. We're almost done. I know. If the classified's written somewhere, it's not yours anymore. It's, the United States's. All right, third, for similar reasons, President Trump's motion to dismiss based off of prosecutorial misconduct and due process violation requires a hearing and should be ultimately granted. So I think this is interesting too. He's saying to the judge, hurry up and make a decision. So, he's kind of pushing the judge now as well. DOJ, NARA, and the Biden administration, the FBI, and subsequently the special counsel's office colluded on the basis of non-existent authority under the PRA to demand records and responses to which they were not entitled to execute search warrants based on legally meritless and unprecedented PRA arguments. So they were after his grocery list, everybody, to illegally pierce President Trump's attorney-client privileges based on similar flawed claims and to initiate this wrongful lawless prosecution. Aren't they claiming 3 different things? Yeah, they are. So we have prosecutorial misconduct is still out there, and then due process violations. So we've got constitutional law violations as well as his misconduct issue. Now, Jack's responding to all of these so far. Second, presidents alone determine. Yes, he's saying and not even just first and second. What's so interesting about the language here is that he is saying he himself, just Mr. Trump gets to make those decisions. What any other presidents do, that's not about him. And that decision can't be made. The statute needs to be repealed. Remember, he said the Presidential Records Act and the Espionage Acts should be repealed. He said both of them should be. They should be repealed, but anything that's applicable to him is his decision. It's only him. And that's what is really, it doesn't work that way. That's what's so, overwhelming, I guess, for us to watch is that this one man is like, well, dude, it's just me. I don't care about what Clinton did. I don't care what anybody did. For me, I get to make this decision. And so you can't charge me because I get to make the decision. And yeah, it's overwhelming. All right, fourth, because of the non-particularized and unlawfully executed search warrant that was used to raid Mar-a-Lago improperly. By the way, this was approved by SCOTUS, just FYI. The U.S. Supreme Court approved that. Improperly delegated to review the PRA categorization decisions. Again, that's not the issue. We don't really care, what you had on your grocery list. To agents executing the warrant, which purported to authorize the seizure of presidential records. The fruits of that search must be suppressed on that basis and due to the other deficiencies identified in our suppression motion. So this is his motion to suppress, where he's saying that needs to be decided as well. Oh my God. No, Mary, no. Fifth, the proposed jury instructions relating to scenario A illustrate that if this case is presented to a jury, which it should not be, the jury would be forced to resolve factual issues relating to not only the PRA categorizations, but also documents' alleged classification status. As such, the aspects of President Trump's motions to compel bearing on classification status and declassification efforts should be granted for the reasons set forth in the classified supplements supporting these motions and related reply submission. Yes, he has said that the Constitution should be repealed. Yes. That was a particularly difficult day. I've done a post on that. Finally, both scenarios posited in the court's March 18th order are consistent with President Trump's position, which again is frightening because Jack has said they are absolutely outside of law. That this prosecution is based on official acts that President Trump took during his first term in office. And this is another issue, everyone. He's saying these are official acts. I decided what was a presidential record, what was not a presidential record. So, number one, he decided whether or not his grocery list was important or not important. Number two, he made all of those decisions while he was president. So the actual moving of the stuff to his Florida home, which is where the Espionage Act comes in, because you moved it out of the White House. If you just left it in the White House, we wouldn't have been charged. That's not espionage. If you leave classified documents where they were originally, they're no longer removed, right? But it's the fact that he moved them. He didn't move the documents until he was out of office. He's not asking for a jury now. Yes, we shouldn't have a jury. So remember that, everyone. He's saying, well, all of this happened when I was president, but it was actually the movement of the papers to his home in Florida, away from the safety of the White House, that is the violation of the Espionage Act. All right? The special counsel's office cannot prevail without offering evidence of official acts, such as exercises in classification authority, declassification authority, receipt of presidential briefings during which the documents at issue were allegedly presented, and the PRA categorization. However, the office may not offer such evidence under the presidential immunity doctrine. Oh my goodness gracious. Now we have presidential immunity. These circumstances further support President Trump's request that the presidential immunity motion be held in abeyance pending the Supreme Court's resolution of Trump v. U.S., and to the extent the case is not dismissed on other grounds beforehand. The need for an evidentiary hearing follows that ruling in order to prevent the office from violating the presidential immunity doctrine. All right. All right. I don't know, everybody. I don't know what's going on with these fellas. Oh, my goodness gracious. It's a lot. So, right. So, let me just hold on, everybody. Let me grab Jack's response real quick, everyone, so we can just kind of clear that up. Let me go grab it just one moment.
Okay, just a minute. Just a minute. Sorry, everybody. I usually have all of my stuff together, but sometimes I don't. So here we go. Let me just clarify this real quick. All right, so pull this up, just one moment. All right, so if we look here, let me just 1 second. Yeah, true story. So I think it's important here, again, that we remember when we're going through all of this that the Presidential Records Act has its own requirements. Okay, and it specifically says it establishes a public ownership of all presidential records and defines the term presidential records. It places responsibility of custody and management of incumbent presidential records on the president. It governs official records of the president and vice presidents that were created or received after a particular date, and changed the legal ownership of the official records of the president from private to public. So I think that's the best way to look at it. Again, the records that they're making in the process. Right. So what Trump is saying is that they're all private, and so I get to have them. And under the Presidential Records Act, some things you can have, but other things you may not have, and it depends on what it is. It's not civil. It's not criminal. You're right. It is civil. It's not. It's an administrative piece, so it's civil. So I think Jack put it best here. Let's see. Let me see if I can find the exact spot. All right, here it is. So, as the government has previously explained, there is no colorable argument that any of the documents charged in the superseding indictment is a personal record under the PRA. So, the presidential records will set out what a personal record is, meaning it's a document of purely private or non-public character which does not relate to or have an effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. So, again, we're talking about, let's just say, let me give you another scenario then, everybody. Here's another drawing. I hope you're all ready for it. All right, so let's say we have a classified document and Mr. Trump puts on it his grocery list. But his grocery list includes a present for the president of Turkey. Okay. And Diet Coke. All right, so the fact that he's getting a present for the president of Turkey, would that be a personal document? Would that be a personal thing or not? Because he's getting it as the president of the US, right? Right. So if his grocery list, let's compare. One grocery list here is personal. Coke, bronzer. This one is a presidential record. Number one, he needs to get a gift for the queen at the time. The queen, all right, needs to get a gift for the queen. Needs to get some, right, bronzer. He needs to get a present for the president of Turkey. And 3, the German woman that he did not like, Angela. Oh my gosh. So he needs to get some squirt guns. So this list, personal. This list, presidential record, because it's a list of things he needs in order to do his job as the president. Merkel. Don't forget, that's getting complicated. So, but if the Coke and the bronzer are on the back of a classified document, he still can't have it. All right. So, if it's within the scope of his job or showing how to do his job, all right, now we have a presidential record. If it's completely private, like, I don't know, check stubs that you pay your lawyer for a situation before you were president, then that is not a presidential record. It seems so simple. I know. And that's why sometimes it's frustrating. And when Jack is in here trying to explain things, he's getting really frustrated. Trump has nevertheless sought to inject the Presidential Records Act into the trial of this case by suggesting he may have designated the documents as personal shortly before his term of office ended. That if he did so, such a designation would be impervious to subsequent judicial review, that his possession of any documents he designated as personal under the PRA was authorized for purposes of the Espionage Act. Even if contrary to the classified records order, as the government has explained, those contentions are both meritless and fatally undermined by Trump's concession that the Department of Justice may seek to recover such documents in a civil suit, in which a court would be perfectly free to determine whether a particular contested record was personal or presidential. So this is the issue. If we want to make this argument on if it was personal or presidential, now we have a Presidential Records Act issue. And we're in civil court. Is it personal? Is it presidential? Is my grocery list, maybe that gift was to a different Angela. That's personal. So let's fight it out. But in the end, neither is a classified document. Okay. Where's the gold ring from? Oh, I'm not sure. That's a good question. I'm not sure, actually. It has a little flaw in it, so I picked it up somewhere. I'm not sure. But yeah, this is one of my favorites. Time to get the spring rings out, everybody. Spring rings. Now it's personal, exactly. So let's fight. Let's fight it out. Is it a personal record? Maybe. Is it presidential? I don't know. Let's fight. Let's go to court. Let's fight about it. Sure, we can do that. But either way, it's not a classified document. Because the classified document is why we're dealing with the Espionage Act. If we were just talking about personal or presidential records, we would just be, in civil court. Like, well, what's this one? Well, I really think it should be personal. Fine, let's fight it out. New big ring to the... Oh, I love it! Desert skies, yes! Of course. Which is less valuable? That's funny. Seasonal rings, well, absolutely, Thomas. Absolutely, it was time. Spring rings. All right, everybody. So is everyone pretty clear now on the Presidential Records Act? Presidential Records Act, is it personal? Is it presidential? So is my grocery list personal or is it presidential? I don't know. Let's fight about it. But either way, it's not classified unless the backside of it has classified information on it. Then it's classified and you can't take it with you when you leave. Yes, thank you. Except for declassifying. So, right. Well, that's the thing, Cecilia. That's the whole thing. When we get to any kind of a classified record, if we want to talk, this is not classified. Let's just say it's classified. All right. So this sheet is classified. Now, Mr. Trump is like, I'm going to declassify it with my mind. And the thing is that there's actually a procedure that you have to go through in order to declassify it. You can't just think of it. You can't just think really hard and be like, ooh, I'm thinking so hard, I'm going to declassify it. No, there's like a procedure. You have to do 1, 2, and 3 in order to declassify it under the executive order. Did Mr. Trump do 1, 2, and 3? No. All Mr. Trump did was think about it, allegedly. So if you want a classified document declassified, you have to do 1, 2, and 3. You don't just get to say it's declassified. There's no magic wand here, all right, that's like, ooh, all of a sudden it's declassified. No. You have to do 1, 2, and 3 in order for it to be declassified. And this is set out in the executive order. How to declassify it is set out in the executive order. And in the executive order, it says you have to do 1, 2, and then 3, and then boom, it's declassified. It's all yours. And you can do that. Don't draw anymore. Oh no, Frank, no. My drawings are too bad. All right, there we go. It's not Hogwarts. The rules don't apply to him. Well, I mean, that's kind of what he's saying. So it's a bit frightening. So, all right. So let's take a look at his proposed jury instructions. So he does actually have some suggestions. I think he said 1, 2, 3 is a declassify. I mean, oh my goodness. I do have the executive order. What's 1, 2, and 3? Well, right. You have to look to the executive order. Now, I have that in the other room. And I've done multiple presentations on it. But if you pull that executive order, which is available to everybody, look, here it is right here. This is the executive order, everyone. And in executive order 13.526, it sets out exactly how to declassify it. And if you don't, then you can't declassify it. Right? And that makes sense. You have procedures to classify. You have procedures to declassify. If all it was a stamp, anybody could get a classified stamp and then just like scratch it out. He wiggled his nose. That's funny. Oh, but yeah, I mean, come on. All right. His third wish. Oh my gosh. All right, well, let's take a look. Let's take a look here at, you just thought it was, yeah, you can't do, like, what's the general, think of like the highest ranking general that can come in with like a magic pen or just a regular pen and be like, wow, this is classified information. He can't just be like, well, I guess it's not now. I mean, that it doesn't work that way. We have procedures that we have to follow, for stuff. All right, so here's our proposed jury instructions. This was added as Exhibit 1, I think, Exhibit A, one of those, to Mr. Trump's thing that we just read. So we have introduction with counts 1 through 32. We have the elements of possession, unauthorized, a person entitled to, national defense, closely held, potential damage, and willfully. I think this is very interesting to take a look at how he's setting this out. Now, none of this is reinventing the wheel, although some of it is kind of like odd, but we have examples that we can use for all of our cases. And so he has multiple examples. So when he comes through this, he's not having to rewrite everything. He can use the examples or the boilerplate language that's been available before, but he's kind of shifting things around a little bit. So let's take a look. Here we have counts 1 through 32 charge President Trump with willfully retaining national defense information. And then again, because this is a jury instruction, I'm going to list the elements now and then provide more detailed instructions regarding each of them. For each of counts 1 through 32, the government must prove beyond a reasonable doubt the following 7 elements.
First, the government must prove beyond a reasonable doubt that on or about the dates alleged in the count you are considering, President Trump possessed the documents specified in that count. Now, quite frankly, this is the first time I've seen something that looks appropriately legal here. So this is an appropriate jury instruction. You know, I mean, with the President Trump and all of that, I don't know. But this is an appropriate sentence. Second, the government must prove beyond a reasonable doubt that on or about the dates alleged in the court, in the count you are considering, President Trump was not authorized to possess the document associated with that count. This is also correct. Like, my mind is blown, everyone. It's correct. Third, the government must prove beyond a reasonable doubt that President Trump failed to deliver the document associated with the count you are considering to a person entitled to receive it. Now, this particular section may not be correct, and we have a footnote here that goes into that a little bit. Although the special counsel's office has argued that the entitled to receive language is not part of the actus reus. Actus reus is the act. We have to have an act and an intent in order to have the corpus delicti, or the body of the crime, or the crime equation. So he's saying here, this element has been included in instructions relating to document retention cases. So he's saying this language has been used in other kinds of cases, and so he'd like to add it here. Will it be allowed? We just don't know. And then fourth, the government must prove beyond a reasonable doubt that the document associated with the count you're considering contain information related to national defense, which I am going to refer to as national defense information. So this is questionable. This is questionable because under the Espionage Act, we do have a national defense. That's one of the categories that has it. But we also have just classification. If it's classified, the reason why it's classified isn't what the question is. The question is if it's classified. So I would say this one is questionable. Who's raising the charges? I would say the person raising the charges are the people of the United States of America, right? Fifth, the government must prove beyond a reasonable doubt that any national defense information in the document associated with the count that you're considering was closely held by the United States. And then we have number 2 here. District Court in the Southern District of Florida described closely held concept as a separate element. So I think this one would be questionable as well. Going to be able to review the classified documents to some degree, but you know, again, the content, that's what's so frustrating about all of this, is the content itself is irrelevant. If it is a classified document, it has to have met a certain level. It had to pass 1, 2, 3. It passed 1, 2, 3, and because of that is classified. So what the actual content of it is should be irrelevant, but it's being fought out right now, so we don't know. We don't know. Yes, SIPA is definitely a part of it, the Classified Information Procedures Act, which is making sure that each level is protecting that information, but that's why it's being fought out. No. This is Trump's proposed instructions here. Right. This is Trump's proposed. 6, the government must prove beyond a reasonable doubt that the disclosure of any NDI in the document associated with the court that you're considering would be potentially damaging to the United States or useful to an enemy of the United States. Does the jury need to make the decision that a particular document, everybody, would be potentially damaging to the United States or useful to an enemy of the United States? Is that for a jury to decide? Is that for a jury to decide? No, it's already been decided. That's why it was labeled classified. Right. That's crazy. This is crazy town. Right? Crazy town. All right, number 3. Here we're citing some cases. The court gave a limiting instruction to the jury that in order to show relationship to the national defense, the government must prove that disclosure of information in the document would be potentially damaging to the national defense
or that the information in the document disclosed might be useful to an enemy of the United States. And then we're citing these cases, one's 1988, 1978, 2012. In prosecutions under both the documents and the information clauses, the government must show that the disclosed NDI relates to the national defense, meaning that it is closely held and that its disclosure would be potentially damaging to the defense, meaning, in the United States, and might be useful to an enemy. And then we're quoting the Morrison case here. Special counsel office acknowledges that there were certain circumstances where a potential harm instruction is appropriate, and it would be something else that the jury would be asked to find. So right here, we are seeing that Jack has already said, no, we don't need that. If we need some kind of instruction on potential harm, we'll deal with it when we get to it, but we're not there yet. The document is, they're not declassified. Oh my goodness gracious. No, it's all classified. It's still not declassified. That's a great question though, everybody. If Mr. Trump can declassify the documents just by thinking about it, are they all declassified now? So what's the big deal? Give me those nuclear codes. Seeing that stuff may put the jurors in danger. Exactly, Cozy. It's not their spot. It's not their position. They shouldn't have to do that. And we shouldn't ask them that. They shouldn't have to make that kind of a decision. So we're asking them a lot of things, but that's not one of them. So here's 7th. The government must prove beyond a reasonable doubt that President Trump acted willfully. So I question this because I've not read the statute to figure out exactly what the intent level is needed, but could be something along those lines as well. What would you do with the nuclear code? I would write somebody a letter. I'd say, dear sir or madam, why is it that I have nuclear codes right now? How is that possible? I would say, you all need to work on your security. That's how I would go about it. All right, let's go through a couple of elements here, everyone, while I still have some battery left. The codes are changing. Well, yeah, but even so, you can still get information from old information, The fact that someone could possess it that shouldn't have the authority to possess it is really disturbing. All right, element 1, possession. The first element that the government must prove beyond a reasonable doubt is that on or about the dates alleged in the count you are considering, President Trump, again, this is how you know that this was written by Mr. Trump's team, possessed the documents specified in that count. The term possession includes actual, constructive, sole, and joint possession. I'm going to define each of those different types of possession. Actual possession of a thing occurs if let's just see if his legal standard is correct in here. A person knowingly has direct physical control over it. And then we have footnote B here. Special instructions S6 11th Circuit pattern instructions. Okay, so this is what I'm talking about. So we don't have to reinvent every single instruction. So they just copied this instruction for actual intent or actual possession from the pattern instructions here, and they just plugged it in, which is absolutely fine. In order to find that President Trump acted knowingly, the government must prove beyond a reasonable doubt that the act was done voluntarily and intentionally and not because of a mistake or by accident, which again, this language is very typical. And this is a basic instruction, B9 of the 11th Circuit pattern. So the special instruction is because it has to do with the documents. The basic instruction is just an overall, pretty much in any kind of case, you would need to have that. So that's that distinction between those two kinds of jury instructions. Medical science has not yet devised an instrument which can record what's in one's mind in the What? What is this? Oh my goodness. All right. Sorry, everybody. I thought we were okay, but I was wrong. Medical science has not yet devised an instrument which can record what was in one's mind in the distant past. Rarely is direct proof available to establish the state of one's mind. All right, that's true.
State of mind may be inferred from what a person says or does, his words, his actions, and his conduct as of the time of the occurrence of certain events. All right. The intent with which an act is done is often more clearly and conclusively shown by the act itself or by a series of acts than by words or explanations of the acts uttered long after the occurrence. Accordingly, intent, including knowing and willfulness, as I will define that term for you later today, are usually established by surrounding facts and circumstances as of the time the acts in question occurred or the events took place, and the reasonable inference to be drawn from them. So this is cut and pasted not very well. All right, it looks like we've got a 4 jury instruction. So this is a specific case that they're pulling here, but it looks like they've added a little bit here. I would say this is a share. All right, this is a great example. They've pulled out another jury instruction from another case that's similarly situated, which is what you're supposed to do. But it seems to me like it's kind of cut and pasted in here. It's not smoothly added in. So I think this could be better. It's more of it's too abrupt. So I think this could be reworded. But if they're pulling it out from another case, I'd have to take a look at that case language. Why? I ask myself that every day. All right, so keep going here because I think it's helpful to pull out where they're getting these instructions from, which is exactly what we do. We pull from other cases, we pull from pattern instructions in other situations. Constructive possession of a thing occurs if a person does not have actual possession of a thing, but has both the power and intention to take control over the thing later. That's number 7. Special instruction. So that's going to match up here. We have special instruction 6. These are the same. So they're coming out of possession instructions. Therefore, constructive possession requires proof beyond a reasonable doubt that President Trump was aware or knew of the document's presence, and 2, had the ability and intent to later exercise dominion and control over that document. And then we have footnote 8, which is the Perez case defining constructive possession in the context of 18 U.S.C. section 924C, which is also showing the example for the 4 jury instruction. So that gives, why are we only on page 3? Jim, true. We're not going to get through we're not going to do the whole thing. Oh my gosh, that's so funny. There's a recording of him waving a classified document. Yes. Yes, there is. And that is good, excellent evidence. So we're still going through element 1, everyone here. Sole possession of a document occurs if a person is the only one to possess it. Joint possession of a document occurs if 2 or more people share possession of it. And then we have footnote 9 here, special instruction again. This is the possession trilogy that he's going through. So that makes sense here. Keep these legs up. I will be happy to always be teaching about the law. I don't care who wins in November. I'm just here to teach about criming. Possession cannot be found solely on the grounds that President Trump was near or close to a document, nor can the government. I'm sorry, everybody, but whenever I explain possession in class, I always would use, instead of a document, I would always say, so think in your mind if you had a can of something that you shouldn't have, all right? And if you just put the can down and you walk away, do you still have possession? So each time it's document, I'm like, a document? Or is that like a 40? What are we talking about? Possession cannot be found solely on the grounds that President Trump was near or close to a document, nor can the government meet its burden of proof on the possession element of a particular count solely on the grounds that President Trump was present at the scene where the document was discovered, or solely because President Trump associated with a person who did control the document when it was discovered. I'm sorry, everybody. I apologize. It's getting late.
However, these factors may be considered by you in connection with other evidence in making your decision whether the government has proven beyond a reasonable doubt that President Trump possessed a document in connection with the first element of each counts 1 through 32. And then we have footnote 10 here, and that's going to be the forged jury instruction. Again, this is just another case dealing with a similar type situation. If you find that the government has failed to prove beyond a reasonable doubt that President Trump possessed the relevant document during the time frame alleged in the count, you are considering mark not guilty for the count on the verdict form. If you find the government has established this element beyond a reasonable doubt, then you should consider the second element. So, and that's how our jury instructions go. It says if you do yes, then you go this way. If you say no, then you go this way. And our jury instructions are meant to really build off of each other. All right, so I'm not going to go through all of the elements because that would just be more than any one person can handle. But let's fast forward here to, let's fast forward and see what we have towards the end. Because I think this is important. So we have one of the elements as a potential damage. And again, this is questionable here. So let's take a look at it. Choose your own verdict. It really is. You got it. That's exactly right. I think that's the best way to put it. If you do this, then you go to the next question. If you do this, then you go to a different question. And then eventually at the very end, you have your verdict. All right, element 6, potential damage. The sixth element that the government must prove beyond a reasonable doubt is that disclosure of the national defense information in the document would be potentially damaging to the United States or useful to an enemy of the United States. Now, this again is one of those that I think is very questionable here. If you find the government has not proven this element beyond a reasonable doubt for the count that you're considering, mark not guilty for that count on the verdict form. If you find the government has established this element beyond a reasonable doubt, then you should consider the seventh element. So that's all they wrote. They could have put quite a bit more information in here, like how exactly are they supposed to make that determination? So this particular one is highly, highly questionable here. How can you prove potential damage when you're aren't allowed to see the document? Well, right. I mean, how is anyone in our jury supposed to know if a document has potential damage to us, right? I mean, that's above my pay grade, and these jurors are getting paid like, $10 a day. All right, so let's go into willfully. It is our last element, everyone. We did our first one and we'll do our last one here. Full immunity for a lot of good. Well, I don't know, VC. I'm still waiting to see what his immunity deal is. We will have to see. All right, element 7, willfully. The seventh element that the government must prove beyond a reasonable doubt is that President Trump acted willfully. Again, friendly reminder, we know that this is from Mr. Trump's team because he's calling himself the president. The word willfully means that the act was done voluntarily and purposefully with the specific intent to violate a known legal duty, that is, with the intent to do something the law forbids. And then we have, we have footnote 38, basic instruction here from the pattern instructions. President Trump respectfully submits that under the circumstances presented by this case, the Section 793E charges involve a highly technical statute that present the danger of ensnaring individuals engaged in apparently innocent conduct. Oh my goodness gracious. Therefore, the government must prove more that the defendant knew that his conduct was done with a bad purpose to disobey the law in general. So he's saying you actually need to prove more than beyond a reasonable doubt. Oh my goodness. All right. President Trump's conduct was not willful if it was due to innocent intent, negligence, inadvertence, or mistake. 39, the for jury instruction here. So that flips us over. When considering the evidence relating to this element, you may consider, as I explained earlier, that President Trump was authorized to possess the documents at issue in counts 1 through 32 during his term as president. So during his term, he was authorized, but then he was no longer
authorized as president. You may consider evidence that the government officials discussed classified information with President Trump and provided classified briefings and documents to President Trump before and during his presidency, but not after, including inside President Trump's private offices and residencies, such as at Bedminster, New Jersey, and Mar-a-Lago in Palm Beach, Florida, as well as at Trump Tower in New York City. You may also consider, as I explained earlier, that President Trump acted as an original classification authority. While he was president of the United States, which means that all classification decisions during his term as president were based on his authority, and that he also had absolute unreviewable authority to declassify documents and information when he was president. You may also consider, as I explained earlier, that former presidents, vice presidents, and other government officials are authorized to possess documents containing classified information under certain circumstances. Certain circumstances, everyone. Let's just remember that. And I don't think it's these because there's been a criminal trial going forward. Finally, you may also consider, as I explained earlier, evidence relating to former presidents, vice presidents, and other public officials being authorized to possess documents containing classified information without criminal prosecution by the government after they left their positions. And then we have footnote 42 here on the superseding indictment, quoting Trump's statements regarding the practice of former officials maintaining access to our nation's most sensitive secrets long after their time in government has ended. Oh, I didn't know he said there was a quote. Oh, and then we've got the Hur report. Everybody, the Hur report has been pulled in. Oh my gosh. Past presidents routinely took national security files, including briefing materials for the president, records of negotiations with foreign governments, correspondence with foreign heads of state or governments, and correspondence with or directives to agencies within the executive branch on foreign affairs. You know, I don't see military plans in this list or nuclear codes. Oh my goodness. All right, referring to DOJ's prior treatment of former presidents and vice presidents who kept national security materials. And then there's a briefing transcript here that we're citing. And U.S. House of Representatives Permanent Select Committee on Intelligence, March 1st. And then we have a website. All right, so that was the last one. Oh my goodness gracious. All right, everyone, we made it. We made it through. Oh my gosh. All right, so these were the proposed, the proposed instructions that Mr. Trump has submitted along with his request that the Presidential Records Act and the Espionage Act be overturned and that the judicial branch has no authority. Can they really count? Well, I don't know anymore. This whole website situation at this point, I don't know. I feel like no judges have really been calling anybody out on it. So at this point, it's like whatever works. Whatever works. Is there any reputable judge that would accept these? I think at this point, the judges are like, whatever, just file it. Because we've got so many appeals going on. We've got so many questions going on. This is Judge Cannon's court. She's asking for, proposed jury instructions on hypotheticals involving misstatements of law. I mean, it's like the whole world's gone crazy. Will the jury see the documents? I don't know. I don't know how they're going to work on that. Can the plaintiff object? Well, yes. And again, these are just proposed. Both of these sets are just proposed. I don't see how any of this would be allowed to be used. Cannon's a hot mess. Well, you're not wrong. You're not wrong. You're not wrong about that. So she asked them for proposed instructions based off of two hypothetical scenarios involving the Presidential Records Act, which, as we know, is not relevant here. So we were able to put it back in. So excuse me, everybody. Exhibit A for Mr. Trump that he mentioned was what I just went through here, was this. So you can kind of see whenever they add an exhibit to their filing. So 427 here at the top. And if you see 427.1, that's how you know that this is the exhibit that goes with that document. Yep. So this is all just, suggestions and kind of kicking the ball around for Judge Cannon's hypotheticals. So there was that. Now, if you are interested, I do have here, let me just make sure. Just as a reminder, I do have Judge Cannon's response, all right, to dismissing off of the Presidential Records Act. I could go through that. It's only a page. It's only literally 2 pages. But we do have this order. Okay, yes, let's see that. Okay, between each of the filings. Yeah, I mean, there's a pretty, excuse me, there's a pretty big difference. They have different strategies. Yes. Okay, let's do that. So they had different strategies. Jack came at it like, I don't even know what to tell you because the law is being misstated. So you might as well just, toss this case out. And then Trump's coming in and saying, hey, there's some more motions to dismiss. Do you mind ruling on those or having hearings? First of all, and then second of all, everything you said was great. I thought that was funny. So yes, I've got just enough voice to do one more here. So Florida ruling on Presidential Records Act here. So this is Judge Cannon's ruling. I'll just put this over here just to remind everybody of what she ruled earlier. All right, so here we go. One last order from Judge Cannon. We have an order denying the defendant, so Defendant Trump's motion. See, she's even writing Defendant Trump. There's no President Trump here. Denying Defendant Trump's motion to dismiss the superseding indictment based on Presidential Records Act. So this matter comes before the court upon a motion to dismiss the superseding indictment based on the Presidential Records Act filed by Defendant Trump. And then we have footnote 1 here, which is defendants Nada and De Oliveira join in the motion. The motion brought pursuant to Rule 12b3b5 for failure to state an offense seeks dismissal of counts 1 through 32 of the superseding indictment. So just as a further reminder, 1 through 32 is one for each one of the documents. There are multiple other counts, but 1 through 32 are specific to the documents. So the superseding indictment based on the Presidential Records Act, those counts charged defendant Trump with willfully retaining and failing to deliver documents containing national defense information without transmission, communication, or delivery. Under 18 United States Code, Section 793E, also known as the Espionage Act. The motion also seeks a derivative dismissal of the remaining counts against defendant Trump, namely the obstruction of justice in 18 United States Code, Section 10,001, counts set forth in counts 33 through 38 and 40 and 41. The special counsel opposes the motion. The court heard argument on the motion on March 14th of 2024. It's so rare to get a written order from Judge Cannon. It's just so exciting. Let me get the written order. Yay. Fully advised on the premise, the motion is denied. Bound by the 4 corners of the superseding indictment, counts 1 through 32 track the statutory language and essential elements of the charged portion of 18 U.S. Code Section 793E, which again is the Espionage Act. See 18 U.S.C. Section 93E, making it illegal to have unauthorized possession of any document relating to national defense and willfully retaining the same and failing to deliver it to the officer or employee of the United States entitled to receive it. Those same counts make no reference to the Presidential Records Act, nor do they rely on the statute for purposes of stating an offense. As for the remaining counts against defendant Trump, counts 33 through 38, 40 to 41, they too track the applicable statutory language and essential elements of the charged crimes. 18 U.S.C. sections 1001, 1512, 1519. More generally, the superseding indictment specifies the nature of the accusations against defendant Trump in a lengthy speaking indictment, which embedded excerpts from investigative interviews, photographs, and other content. For these reasons, accepting the allegations of the superseding indictment as true, the Presidential Records Act does not provide a pretrial basis to dismiss under Rule 12b3b5. Either as to counts 1 through 32 or as to the remaining counts, all of which state cognizable offenses. Separately, so this is where she goes after Jack. All right. So here we go. Separately, to the extent the special counsel demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust. So she's saying she's not asking for finalized jury instructions. And if Jack's anticipating these as being finalized jury instructions, then it's unprecedented and unjust. The court's order soliciting preliminary draft instructions on certain counts should not be misconstrued as declaring a final definition on any essential element or asserted defense in this case, nor should it be interpreted as anything other than what it was, a genuine attempt in the context of the upcoming trial to better understand, whoopsies, sorry everyone, my battery went out. Hopefully the light's okay. Nor should it be interpreted as anything other than what it was, a genuine attempt in the context of the upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. As always, any party remains free to avail itself of whatever appellate options it sees fit to invoke as permitted by law. Done and ordered in chambers in Florida by Judge Cannon. So there we go. There's Judge Cannon's order. She was making it pretty clear to Jack that she was just wanting to kind of kick this issue around. And if he wanted to appeal, that's up to him. But these were certainly not meant to be finalized jury instructions. So I thought she did a pretty good job on that. Appeal me, I dare you. That's what she's saying. Well, yeah. Yeah, and I think she's saying, too, appeal me based off of these being anticipated final jury instructions. So she's not going through and answering this issue about the Presidential Records Act that Jack was asking. She's saying, if you feel I'm doing the wrong thing with jury instructions, then appeal me. But her order here, setting out that the Presidential Records Act is not grounds for dismissal, is basically her saying the Presidential Records Act doesn't have anything to do with the charges. So, I mean, it's kind of weird. It's kind of a weird situation. Why have them do these jury instructions? Well, that's exactly right, Cynthia. I think that's the whole issue. And what Jack was saying, too, is like, hey, you know, why are we even doing this if you are not considering the Presidential Records Act as being part of this? Because she just came back with this order saying the Presidential Records Act is not part of this. So what are we doing here? Yeah, then why? Disingenuous. Yeah, I mean, it's a bit odd though, isn't it? Because she's dismissing his motion to dismiss, so it's off the table. And she's saying to Jack, appeal me if you think that these are my requests for final jury instructions, is how I'm reading it. Wasting everyone's time. It seems that way. It does seem that way. Do you think the judge is treading lightly by issuing the order? I think the judge was frustrated. I think, you know, in all honesty, everybody, I think she was trying to, you know, do something here where she's like, hey, let me give you these hypotheticals. Maybe they can kind of work these out and come back to me and tell me what you're thinking. And I get that feeling only because she writes in here that she had a genuine question or she wanted genuine feedback on what was going on. So perhaps she just did not realize the kind of blowback she was going to get by asking this kind of question. And that's something that happens when you just don't have experience, when you don't realize that if you're tossing hypotheticals like this out in this manner, misstating law like this, the attorneys are going to be like, what are you doing? What are you doing?
Okay, she's not competent. It could very well be a competency question. It could absolutely be a competency question. She still didn't rule. Well, she ruled that the Presidential Record Act was not qualifying to dismiss the case. And she ruled that this was not a definitive jury instruction exercise. She just was asking questions. That's the only thing she ruled on. She did not answer Jack's question that he presented. And I think if I can pull up his original, I think he was only like 2 paragraphs in when he was like, "What are you doing?" So let me see if I can find page 2 here. Find page 2 of his request. Here we go. Let's see. Page 5. Page 4. All right. Here we go. So this is Jack's. Okay. Moreover, it's vitally important that the court promptly decides whether the unstated legal premise underlying the recent order does, in the court's view, represent a correct formulation of law. So he's asking her, do you really think this is the proper statement of the law? Do you really think that? If the court wrongly concludes that it does and that it intends to include the PRA in jury instructions, so again, we're only talking about this issue of jury instructions regarding what is authorized under Section 793. It must inform the parties of that decision well in advance of the trial. And she's saying, I'm not going to do that because I don't have to, and I think it's rude of you to ask me. So that's what her answer was. The government must have the opportunity to consider appellate review well before jeopardy attaches here. Can she dismiss the case? Well, I mean, she has to have a motion to dismiss. She has to have proper grounds to dismiss the case. And of course, too, as I've said, before, don't forget, everybody, we've got 32 documents. I get this mixed up because we have 34 counts in New York. So it's 32 documents here, 34 in New York. But don't forget, we've got tons of documents. These were 32 out of hundreds of documents that they filed. So no matter what happens to this case, Jack could go forward and file another case. So this is just kind of like the first go at it. So this could keep going on and on and on until he's done filing and until, they've hit like 150 documents or however many it was that they found. They could do this each and every single time. So no matter what happens, we're going to keep going. And you don't use a case like this as constitutional learning experience. Oh, Kyle, that's such an excellent point. And that's, I think, what's happening, unfortunately, with Judge Cannon is that she's having to really learn as she's going through this process. And it's painful. And any mess up that she does is going to be 100 times worse than what it would normally be because of what's at stake at this case. So I think so. Is there a date for trial yet? No date for trial. We still are missing some of our motions to dismiss. We still don't have filings on a couple of those. She still has not ruled on the motion to suppress yet or even set a hearing for it. So we still have a lot of motions she has not answered. So I was surprised when she actually finally filed this Presidential Records Act motion, and I think it's because she wanted to put that little dig in there on Jack. But no, she has not answered any of those motions. She has not set a trial date, none of that. Judges to a case, how does that work? It's random. It's completely random. So in Florida, they've got, maybe 9, maybe a dozen judges that could possibly be chosen. So they just spin the wheel and whoever gets the case gets the case. Or draw the name out of the hat or, digital random number is drawn. It's completely random on how it's pulled. Ruled the trial can continue before SCOTUS rules. Yes, she has. She's not held anything. Both sides have put in their requests. Jack's put in his request regarding, hey, can we, July's looking great. Trump's put in his response saying, I don't know about August, but maybe September, I don't know. And then she has not replied to either of those. She was embarrassed for getting the law wrong.
Yeah, and how does she clean it up, right? I mean, how do you clean up something that you screw up when you've got this many eyes on you? That's the other problem here, is that she just has so many people watching her that these mistakes that she might normally be like, whoops, I got to clean that up, that she normally could just clean up, she's not going to be able to do that because the ripple effects are just enormous.
How long will it be to correct appointing incompetent budget?
That's a great question, and I cannot answer. I have no idea. I have no idea. Incompetent judges and biased judges, like that's a whole world of problems outside of my pay grade. She wants it to be after November. Perhaps. I really don't know. I really don't know. Lots of people are saying that. Lots of people are saying, she's biased towards Trump. And, I cannot say technically, legally, that she has risen to a letter where a level where she should be removed legally. I would not be myself. If it was me, I would not be filing yet. Although I have to say the last order that she did regarding these two hypotheticals would have been my last straw. Like I'm at a point now where all it's going to take is one more wrong move and I would be filing. I would be filing. Can Jack's team be insulated now so prosecution can continue regardless of the election? I think so. And I think he, excuse me, I think he has said something about that. And, too, like, we're all like, oh, look, the election, blah, blah, blah. But in the legal system, if you're prosecuting cases like this, you've got a lot on your plate. You've got a ton of cases that you're working on, not just this one. And so for them, every day they get up, they go to work, they try to do their job, they try to not get, harmed, and then they go home. So, and eventually they're going to get up one day and go to work and it's going to be election day and they're going to do their job and they're going to try not to get hurt and they're going to go home. And then the next day they're going to get up and it's going to be the day after election. So for them, it's like they just keep going and it's just grinding every day. You go in and you just do your job. If he wins, he'll pardon himself. Well, I mean, I suppose he can pardon himself technically for the federal crimes. The state crimes, not so much. State crimes, he doesn't have the authority to pardon himself. And I don't know. I mean, what kind of a situation would it be when a president pardons himself from his own crimes? I don't know. It's possible. I can't say it's out of the realm of possibility, but then everything is within the realm of possibility. We have crazy legal filings that are just crazy town. I mean, there's just like, what? There's a lot of stuff going on. Yeah, I think, excuse me, I think this last order on the jury instructions was really Jack's last moment. If he's writing, a paragraph and a half, we didn't even get to paragraph 3 where he's already like, I will appeal this, lady. I think he's had enough of it. He's had enough. Like he's already, dealing with it. He's going through it in DC. He's going through it in Florida. I think we're at a point now where he's like, look, let's just get her done or toss the case because I got stuff to do. Oh my gosh. Yes, we love you. Oh, you're so sweet. You're so sweet. He's ready. I agree, everybody. Now, with that, my friends, I will need to let you go. I'm looking at the clock here. My time is running out. I'm about to turn back into a pumpkin. So I will go ahead and sign off for tonight, everyone. I will be back for my sub chat Sunday, this Sunday, and we will have a fun sub chat. Everyone's welcome to join. I just leave my chat open just to my subscribers as a big thank you. So it's been just a huge eventful week. Thank you all for coming and hanging out with me. It's always a pleasure. Always fun to come and talk about this stuff and try to clear it up. So have a great rest of your weekend, everybody. I know, not a pumpkin, I know. But off to bed I go. But have a wonderful rest of your night, everyone. I will see you all very soon. So take care, and I will be back again on Sunday.